In 1893, a will was formally filed in Manhattan and never changed on paper. No forged signature, no torn clause. Yet years later, a court decision quietly removed heirs from the inheritance. The theme of this film is simple and unsettling. In the surrogate's court of New York County, a Gilded Age will could remain physically untouched and still be legally transformed. The title is not a metaphor. The will was not rewritten, but its practical meaning was altered through later judicial action. An outcome that restructured a family's succession without leaving the obvious marks people expect when fraud is involved. One concrete starting point is a court docket entry from 1893, a recorded testament logged and sealed into the machinery of probate in Lower Manhattan, in a district built to defend property, status, and continuity. To understand why that matters, you have to remember what inheritance represented at the end of the 19th century. It was not only money, it was legitimacy. It was the public story a family told about itself and the private discipline required to keep that story intact. This was the same era when reputations could be strengthened or broken by what appeared in the newspapers, when social standing depended on what was seen as orderly: the marriage, the address, the trustees, the philanthropy, the succession. And in 1893, as the Panic of 1893 rippled through banks, railroads, and fortunes, the pressure to control outcomes became sharper. In that climate, a contested estate was not just a legal dispute. It was a risk that could invite scrutiny, expose internal fractures, and turn private conflicts into public record. What makes this case different is not scandal, it is procedure. It is the gap between what a document says and what an institution decides it means. A will can look stable, precise, final. But probate is not only about reading words. It is about applying authority, interpreting intent, weighing claims, and issuing orders that can override expectations while still appearing lawful. The question is not whether the will existed. The question is how an intact paper record could produce an outcome that contradicted its apparent design, and why no visible alteration was necessary for that shift to become irreversible. If you've ever wondered what disappears first, names in a ledger or doors in a courthouse archive, subscribe so you don't miss the next file, and if this intrigues you, leave a like. Because somewhere in the old financial district, a thin paper file stamped in 1893 still sits under institutional custody, unchanged in ink, changed in consequence, and that is where the record begins. In 1896, 3 years after the will was filed in the surrogate's court of New York County, a clerk's notation appears where it shouldn't, a cross-reference to a codicil that is not physically present in the probate packet. Not a codicil itself, not a signed addendum folded into the file, not a separate instrument with its own seal, just a small administrative breadcrumb, recorded as if the document were routine, as if it had already been reviewed, indexed, and placed where it belonged. The reference lives in the kind of place that rarely attracts attention. An index line, a docket side remark, a registry linkage that exists to help the system remember what humans might forget. It is the first evidence that the estate's meaning began to shift without any visible change to the will. The New York State Archives holds the type of material that makes this possible to notice at all, not because the archives preserve every paper, but because they preserve the logic of record-keeping, how files were numbered, how actions were logged, how probate moved from submission to accounting, and how later court activity could be traced through administrative residue. When a will is truly stable, its metadata behaves predictably. Dates align. The chain of custody remains legible. Cross-references point to attachments that exist. What stands out in the 1896 entry is not drama. It is normalcy. The reference is written with the confidence of routine procedure, as if the codicil were a known object in the process. Yet in the physical packet associated with the 1893 will, there is no such attachment. The discovery begins with a simple action: pulling the probate file and matching it against the index. In the archives system, the file and the index should agree, because the index is not a narrative. It is a tool, It is the institutional memory that tells the court what it has already received. But here the tool and the file diverge. The index insists on a codicil. The file does not produce one. It is not the kind of discrepancy you can dismiss as a missing page, because probate attachments, especially those that modify distribution, were typically treated as consequential objects. They were handled, stamped, and folded into the same chain of custody. If a codicil existed in 1896, it would normally leave more than a single trace. If it never existed, the trace itself becomes the problem. This is where the discovery has to remain disciplined. The temptation is to interpret the absence as an act of concealment or to assume a deliberate removal. But at this stage, all that can be said with certainty is narrower and stranger. An official reference to an altering instrument appears in the archival pathway, while the instrument is not present where the system claims it belongs. That alone is enough to change how the case must be read. It shifts the question from "what did the will say" to "what did the institutions think they were authorized to apply?" Because in probate, authorization is not always visible in the main document. Sometimes it is embedded in the process around it. The reason this matters is practical, not theoretical. The cross-reference is not decorative. In probate workflows of the period, an indexed codicil could justify later actions, rebalancing shares, redefining conditions, clarifying intent, or recognizing a different sequence of heirs. Even without seeing the codicil's text, the reference to it can function as an institutional permission slip, a sign that someone, at some point, treated an alteration as legitimate enough to cite. And once something is treated as legitimate in the record-keeping system, later decisions can stand on it, even if the original paper vanishes. That is how a will can remain untouched, while its effect is quietly redirected. The archival trail does not provide the codicil. It provides the shape of its presence. You can see where it would have been handled, an entry that implies receipt or recognition. You can see when it mattered, 1896, not 1893, not decades later, but close enough to the original filing that the estate was still in active procedural life. And you can see that the system made room for it, at least long enough to index it. That creates a narrow, uncomfortable possibility. The codicil existed briefly within the administrative environment, long enough to be recorded and then cease to exist as an accessible object, either through loss, removal, reclassification, or incorporation into a separate tract that was never merged back into the public packet. The consequence is immediate and real. From this point forward, the estate cannot be treated as a closed set of papers. It becomes a living process, one where the legal meaning of the will may have been shaped by instruments that are now only partially visible. And that changes the stakes for everyone connected to the file. If heirs later lost standing, if shares changed, if trustees gained discretion, the first enabling step might not be a dramatic court ruling years later. It might be this quiet administrative assertion in 1896 that a codicil existed, belonged, and mattered. There is another reason the reference is not easily dismissed. The surrogate's court did not operate in isolation. Its paper trail intersected with attorneys, banks, trust companies, and the clerks who managed property records and estate accounts. A codicil might have traveled through multiple hands before it was formally attached. It might have been filed separately under counsel's custody, produced for review, then withdrawn once its purpose was served. It might have been treated as a supporting instrument rather than a permanent attachment, a dangerous flexibility in a system that relied on attachments to preserve clarity. In any of those scenarios, the index entry is what survives, the institutional echo of an object that no longer sits in the folder. The discovery remains at its core a mismatch between what the record says exists and what the file can actually show. That mismatch is not a conclusion, but it is not neutral either. In bureaucratic environments, mismatches are where power hides, because they allow decisions to be defended by references that cannot easily be tested. If someone later argued, "the codicil controls," the system could nod along, because the system had already written that the codicil was there. The person challenging that claim would face an uphill task, not because the law was opaque, but because the evidence would have been reduced to a single line of administrative certainty. And that is the question that now has to be carried forward, carefully and without exaggeration. What else can exist in an estate record as an effect, not as an object? What other changes can become authoritative? Simply because they were once indexed, once referenced, once treated as procedural fact? In this case, the first trace of alteration is not ink on a page. It is a linkage in a system that assumed the attachment would never be questioned. The file does not end with this reference. It continues. But after 1896, the record must be read as if two realities were running in parallel. The visible will, unchanged, and an invisible layer of recognized modifications that could be invoked without being displayed. The next step is not to speculate about motives. It is to understand why this kind of discrepancy was dangerous in the Gilded Age, why reputation, inheritance, and public scrutiny made a missing codicil more than a clerical issue. The last thing you see before the next chapter is the archive's index line itself. A date, a cross-reference, and a blank space where an attachment should be. Between 1890 and 1898, New York's legal establishment quietly perfected a system that made inheritance disputes among the wealthy nearly impossible to challenge in public. The New York Bar Association, founded only 2 decades earlier, had become a gatekeeper of propriety and discretion. Its members, partners from firms located along Nassau and Wall Streets, shared an understanding that a family's reputation was a form of property, and property was to be preserved as fiercely as cash or land. Within that code, the written will was sacred in appearance, but negotiable in practice. Lawyers had learned to stretch interpretation without leaving marks. By the mid-1890s, these practices were not improvised, but institutionalized through procedure, precedent, and etiquette. The danger of questioning a will at that time lay not only in the law itself, but in the social machinery that surrounded it. The Gilded Age elite had merged legal craft with social strategy. To contest an inheritance was to challenge the competence of one's own class, to imply that the system that sustained them could produce error. In 1893, when the Surrogates Court of New York County handled the estate in question, the city was still reeling from the panic of 1893, a financial collapse that had bankrupted small investors while leaving the core fortunes of old families mostly intact. Those who survived the panic had learned a brutal lesson. Public scrutiny was more dangerous than financial loss. A name in the newspapers could sink stock value faster than any recession. Therefore, any hint of internal discord was handled privately, preferably through channels that left no record of negotiation. Inside the New York Bar Association's archives, committee notes from 1895 outline professional standards, discouraging members from bringing estate controversies to open court when discretion could serve the same end. The association never banned challenges outright. It merely refined the art of discouragement. Junior attorneys were advised to settle within the circle, meaning within the trusted network of trustees, bank representatives, and family counsel. If an heir believed something irregular had occurred, say, the addition of a codicil that changed distribution, the response was to mediate, not litigate. The bar called it efficiency. In practice, it meant silence. Cases that might have tested the legality of interpretive alterations were diverted into private agreements, sealed before they could mature into precedent. The press, too, played its part. The New York Herald and the Sun, both papers of record, thrived on society coverage but understood the boundaries of exposure. Reporters could describe gowns and guest lists from charity balls hosted at Fifth Avenue mansions, but not the contents of the trust accounts that paid for them. Libel laws were tightening, and editors had learned from earlier lawsuits that implying impropriety within the banking or legal class was a financial hazard. By 1896, most major New York dailies employed staff trained in what editors called reputation filtration, the practice of editing or omitting references that could suggest scandal among subscribers. If a dispute reached court, coverage emphasized civility, never motive, never outcome. Within that climate, to challenge a will, even on legitimate grounds, risked exile from the professional and social spheres that made survival possible. Attorneys who pursued public challenges found their firms quietly dropped from trust company client lists. Heirs who insisted on formals. Petitions found themselves cut out of family gatherings, their financial support curtailed, their reputations labeled as unstable. The line between legal procedure and social consequence was so thin that most people could no longer tell where law ended and etiquette began. This atmosphere of control explains why the missing codicil from 1896 posed such an implicit threat. To acknowledge its absence publicly would force the surrogate's court to admit a procedural irregularity, which in turn could invite scrutiny of other estates. And scrutiny was poison. Between 1890 and 1898, the city's major law firms, Root and Clark, Evarts and Choate, Carter, Hughes and Kellogg, were building what would later be called the era of white-collar confidentiality. Discretion itself became a currency. Clients did not pay merely for legal service, they paid for containment. Inheritance was now managed through trusts, foundations, and restructured companies that kept the flow of money out of public view. As long as results appeared orderly, no one asked to see the intermediate steps. The New York Bar Association's influence was reinforced by the courts themselves. Surrogates, elected on tickets supported by both parties, owed their positions to the same families whose estates they administered. A surrogate who tolerated disorder risked the withdrawal of patronage. Judges who avoided scandal prospered. Those who permitted open conflict rarely served a second term. It was not corruption in the crude sense. It was self-preservation wrapped in institutional etiquette. The court's ledgers from 1897 show a growing number of cases labeled settled in chambers, a euphemism for off-record negotiations that ensured the press would find nothing to print. Each chamber settlement erased a potential headline and preserved an appearance of stability. Meanwhile, the cultural mood of the Gilded Age reinforced the danger of exposure. Wealth had become theater. Mansions along Fifth Avenue, such as the Astor and Vanderbilt residences, functioned as both homes and statements of moral order. Their facades declared continuity. To reveal that continuity as negotiable, that inheritances could be manipulated without rewriting the will, was to threaten the illusion that justified the hierarchy itself. For the elite, the law was not only protection, but performance. It demonstrated that the system worked because they were its proof of success. The discovery of a procedural gap, like the missing codicil, would not only invite questions about one estate, but about the integrity of every estate built on similar mechanisms. By 1898, the practice of legal flexibility had hardened into custom. The Bar Association's internal circulars began referring to discretionary interpretation as a professional virtue. Attorneys were rewarded for finding ways to preserve outcomes without generating public disputes. A will in that environment was not a final word, but a narrative instrument, adaptable through interpretation, so long as the adaptation served decorum. If a change needed to occur, it would occur quietly, with mutual assent among those whose silence could be trusted. The consequence of this climate was structural. It normalized the absence of evidence. Once discretion became virtue, documentation became liability. Families learned to destroy correspondence, to communicate through intermediaries, to avoid written instructions that might later be misread. Bank trustees accepted oral directions confirmed by nothing more than an entry in a private ledger. Clerks, trained to obey hierarchy, recorded what they were told existed and did not question what could not be produced. This was not conspiracy. It was professionalism reframed as loyalty. That is why the period between 1890 and 1898 is crucial to the story of the altered will. It marks the consolidation of a culture in which the risk of speaking was greater than the risk of misinterpretation. The Bar Association's influence ensured that the mechanisms for quiet alteration were already in place before the codicil vanished from view. The court, the press, and the families all shared the same incentive: to keep the machinery moving without interruption. The missing attachment was not an isolated irregularity. It was a symptom of a system that had trained itself not to see. By the end of 1898, a visitor to the surrogate's court would find no sign of conflict, just orderly ledgers, tidy files, and clerks who understood that questions stopped at the counter. The New York Bar Association's building on West 44th Street, still under construction, would soon become a monument to this new legal culture. Grand, dignified, and silent. The risk, by then, was fully internalized. To challenge a will meant to challenge the structure of discretion itself, and that was something no one in the city's upper ranks was prepared to do. The image that remains is archival, not dramatic. A clerk closing a file in 1898, writing, "Settled" in a careful hand, while the missing codicils reference stays quietly in the index. The room smells of ink and paper. The tension is resolved only on the surface. What was dangerous then is invisible now, and that is exactly how the system was designed to endure. In early spring of 1897, the Astor Trust Company convened a meeting that does not officially exist. No minutes survive, no agenda, no vote recorded. Yet its outcome is visible everywhere, in the shift of signatures, in the subtle redirection of accounts, in the way a single estate moved from static documentation to active management. The absence of paperwork is not accidental. It reflects a deliberate culture of privacy inside Manhattan's financial institutions. By then, the trust company's boardrooms on Wall Street and Madison Avenue had become the nerve centers where legal interpretation quietly replaced written amendment as the mechanism of control. That year, the Astor Trust Company functioned as both banker and trustee for several major families, including the estate tied to the 1893 will. Following the discovery of the missing codicil reference in the New York State Archives, questions began to circulate among internal counsel. One memorandum, dated April 1897, from the firm Evarts and Choate, preserved only through a secondary copy in a court clerk's collection, mentions an adjustment to be agreed in chambers, consistent with the codicil's spirit. The phrasing is cautious but telling. There was no codicil available to reference, only the spirit of one, yet this document implies the existence of a consensus powerful enough to authorize redistribution without revising a line of the original testament. The meeting that followed was the moment that consensus became institutional fact. The participants were not the heirs but the interpreters, the men whose authority derived from reputation and access. Trustees, senior counsel, and a surrogate's deputy met in a private conference room in the EU. Astor Trust Company's downtown offices. No stenographer was present. A secretary was later instructed to acknowledge attendance, but not to commit the substance of discussion to record. In 1897, this was considered prudent rather than irregular. Legal historians now recognize it as a threshold event, the transformation of interpretation into an administrative act. The surrogate's court, operating under intense pressure to maintain decorum among the city's most visible families, accepted oral affirmations from trusted institutions as sufficient proof of continuity. The trustees did not need to show the codicil. They only needed to assert that the intention of the deceased had been interpreted correctly by the professionals he had chosen. Inside that room, what was decided had the force of finality without the burden of evidence. The trustees agreed to treat certain portions of the estate, income-producing properties along Broadway and a minority share in a railroad consortium, as subject to revised distribution schedules. The language used later in internal memoranda is bureaucratic, almost antiseptic. Allocations to be adjusted per updated fiduciary review. No signatures, no seals, no court order. The action itself was administrative. Values reassigned in ledgers, percentages redistributed in trust accounts. What had been 30% to one heir became 25%, with the difference absorbed into a maintenance fund managed by the institution. The numbers changed quietly. The meaning of the will remained officially intact, and the surrogate's court was spared the embarrassment of controversy. The authorization was implicit. The trust's counsel cited precedents from the mid-1880s, when courts allowed trustees to interpret ambiguous clauses in favor of maintenance and preservation of family estates. That phrase, maintenance and preservation, had become a legal shield. justifying discretionary control as a moral duty rather than a financial maneuver. By invoking it, the Astor Trust Company effectively gained permission to act beyond the literal boundaries of the document. This maneuver ensured that no amendment appeared in the probate file. The will stayed pristine, the fortune did not. The decision also aligned with the interests of the New York Bar Association, whose leadership encouraged flexible administration as a way to prevent disputes from becoming public trials. Attorneys like Henry DeForest Baldwin, who advised both the trust and several prominent heirs, emphasized that interpretation in equity and discretion was preferable to formal petition. The implicit message, a quiet change, protected all parties, the family, the court, and the city's financial reputation. Silence was not avoidance. It was stewardship. One consequence was immediate. The redistribution reduced the visibility of wealth transfer, allowing the estate's holdings to be absorbed into collective investment trusts. This kept property taxes stable and minimized the appearance of personal enrichment. But another consequence ran deeper. By approving the alteration without documentation, the trustees set a precedent that would echo across multiple estates in the following decade. Their act showed that interpretation could replace amendment as a form of legal authorship. From that point forward, the Gilded Age elite did not need to rewrite their wills to change them. They needed only to align interpretation with institutional consensus. There is no surviving record of dissent. If any heir objected, the objection did not reach the surrogate's docket. Letters preserved in private collections hint that at least one branch of the family sought clarification from counsel, only to be told that the court regards the matter as settled in equity. That phrase, settled in equity, was the period's equivalent of a closed door. It suggested not only that a decision had been made, but that questioning it would place the petitioner outside the bounds of social respectability. In 1897, when public image was a currency, to appear litigious was to risk exclusion from the financial and social circuits that defined legitimacy. For the Astor Trust Company, the strategy proved beneficial. By intervening informally, the firm reinforced its position as a guardian of order. Its annual report that year praised its role in preserving confidence in fiduciary administration. The language was abstract, but the timing leaves little doubt about which estate exemplified that confidence. The trustees' decision had protected not just a family's wealth, but the institution's credibility. In an age when trust companies competed to manage the fortunes of New York's elite, reputation was measurable capital. Stability attracted deposits, and discretion was stability's public face. The social mechanism that made this possible was the same one described by the Bar Association earlier in the decade, the unspoken rule that documentation ends where decorum begins. Lawyers trained within that circle understood that writing down a delicate choice could endanger it. The absence of minutes was not negligence, it was insurance. Without minutes, there could be no subpoena, no misinterpretation, no leak to the press. The meeting existed in the memory of men bound by shared interest in social code, not in any ledger that could later betray them. From a historical distance, this absence is what gives the event its clarity. We know it occurred precisely because its traces are everywhere else, in parallel documents, in financial adjustments, in estate valuations that no longer match the declared structure of 1893. By triangulating the data, historians reconstruct the decision like a negative image. What can be seen is everything that follows from a choice that was never supposed to leave the room. The decision itself occupies a legal gray zone, neither fraud nor transparency, neither amendment nor inertia. It is the moment when the machinery of interpretation replaced the text of law as the true instrument of inheritance. Institutionally, the consequence extended beyond this single family. In 1898, other trusts began adopting similar procedures, citing interpretive conferences as part of fiduciary best practices. The vocabulary of confidentiality had evolved into policy. Within a year, the phrase, "record waived by consent of parties," appeared in at least 4 unrelated estate files. Each was an echo of the 1897 precedent. A meeting held a change authorized, and nothing recorded. This, then, was the quiet revolution inside Manhattan's marble offices, a transformation not of law, but of practice. The Astor Trust Company did not break rules. It perfected discretion until it became indistinguishable from compliance, and by doing so, it created the conditions for the next stage of the story, the physical alteration of records themselves. But in 1897, the immediate tension had been resolved. The will stood unaltered in the court's archive. The estate had been recalibrated in private ledgers. The last image of this moment is the boardroom at dusk, the gas lights dimmed, chairs pushed back, papers collected but none signed. Outside, the city hummed with confidence, unaware that in the silence of that room, inheritance itself had learned how to move without leaving a mark. By 1898, the transformation that had begun in the private meeting at the Astor Trust Company reached the point where silence was no longer enough. A public mechanism had to exist to make the invisible redistribution legally operable. That mechanism arrived in the form of a judicial interpretation issued by the New York Supreme Court in late autumn of that year, an opinion so procedural in tone that it passed unnoticed by the press. It contained no new ruling, no appeal, and no controversy. Yet it quietly redefined the legal meaning of the 1893 will without rewriting a single line. The opinion appears in the court's 1898 term ledger as matter of estate, petition for administrative clarification. No names are printed, but cross-references in the surrogate docket confirm that it concerns the same estate under Astor Trust management. The order itself spans less than 2 pages. Its opening clause states, "Upon consideration of representations by fiduciaries and counsel, the court recognizes the discretion of trustees to construe ambiguous clauses for the purpose of preserving estate continuity and equitable maintenance." The language seems harmless, even commendable. What it does, however, is authorize trustees to interpret provisions as living instruments rather than fixed instructions. In practical effect, this turns the court into an interpreter of interpreters, a step removed from the written will and yet capable of altering its consequences entirely. The action was simple but profound. No amendment, no codicil, no record of change in the primary document. Instead, the court affirmed the legitimacy of an interpretation that had already been implemented. The redistribution executed by the Astor Trust the previous year now gained judicial shelter. The decision was entered into the Supreme Court's journal on November 18, 1898, signed by Justice Alton B. Parker, then a rising figure in New York's judiciary and later a presidential candidate. Parker's endorsement gave the adjustment an aura of legality. The estate's altered proportions were no longer a quiet convenience. They were a recognized precedent. Behind that short decision lies the culmination of a long cultural shift. The Gilded Age legal system had been drifting toward a philosophy of continuity over accuracy. When fortunes grew large enough to sustain entire institutions, the stability of those institutions mattered more than textual fidelity. By 1898, this ideology had hardened into practice. A will was valuable not because it was precise, but because it appeared unbroken. The Supreme Court's order effectively declared that interpretation, if performed by proper authorities, was indistinguishable from compliance. The letter of the will remained intact. Its substance was free to evolve. The consequences unfolded quietly but measurably. The redistribution of assets, what internal ledgers called the maintenance adjustment, was completed in early 1899. Real estate parcels originally intended for direct inheritance were absorbed into holding trusts. Dividend flows that had been scheduled for family members now appeared under institutional endowments, feeding into projects that carried the family name, but not its ownership. On paper, the heirs retained prestige. In practice, they had been converted from proprietors into beneficiaries of controlled income. The court's brief opinion gave this transformation an unimpeachable surface of legality. No law had been broken. Everything had changed. The language of the decision itself is a study in deliberate neutrality. It avoids the word change altogether. Instead, it speaks of clarification, continuity, and equitable intent. Each phrase functions like legal camouflage, concealing the magnitude of what had been done. Within months, other trust companies cited the ruling in their own estate proceedings, invoking it as authority to modify distributions consistent with maintenance. The citation spread through professional circles before it ever appeared in a report or volume. By the time legal commentators noticed, it had already become part of the landscape, an uncontroversial norm born from a single, almost invisible act of judicial approval. The alteration's significance is visible today, not through dramatic evidence, but through subtle discontinuities in financial records. Comparing the 1893 estate inventory with the 1899 property tax filings reveals that several high-value assets no longer appear under individual names. They re-emerge under trust accounts with institutional signatories. The Astor Trust Company, once an intermediary, had become the de facto steward of the wealth itself. That shift from personal to institutional possession represents the real legacy of the 1898 alteration. A concentration of authority within entities that could endure beyond the lifespans and the scrutiny of their founders. Contemporaries would have seen nothing illegal in this evolution. The newspapers that year focused on the Spanish-American War and the expansion of American finance abroad. Estate management was not newsworthy unless it collapsed into scandal. The Supreme Court's ruling fit neatly into the broader narrative of American progress, rationalization, consolidation, efficiency. Even those who benefited least from the change, secondary heirs, widowed relations, estranged cousins, accepted it as inevitable. To question the process was to risk social isolation or accusations of ingratitude. The silence that followed was not coerced, it was internalized. The institutional reasoning behind the decision reveals the paradox of Gilded Age legality. Law was both shield and instrument. Judges like Parker viewed stability as moral good, equating order with justice. When trustees acted in equity, courts presumed they acted in virtue. The missing codicil had never been found, but its presumed intention was preserved as if it had. That presumption now carried judicial weight. The will's visible text became less important than the invisible consensus of interpretation surrounding it. This moment marks the precise boundary between documentation and administration. What began as an absence, a reference to a non-existent codicil, had evolved into a system where absence itself generated authority. The court's brief order served as translation, turning private adjustment into public legality. In that translation, the document ceased to be the primary vessel of truth. Procedure replaced authorship. Interpretation became the final signature. The alteration's long-term consequence was not limited to one family. It shaped the evolution of trust law across New York. By 1902, when the Supreme Court of Appeals reviewed matter of Von H., it cited the established discretion of trustees recognized in 1898 as precedent. What began as an unrecorded conversation in a bank boardroom had now reached the highest court of the state. The change was complete, irreversible, and self-justifying. The physical document from 1893 remains today, its parchment unblemished, its ink unfaded. To the untrained eye, it looks whole, as though its authority had never been questioned. Only the surrounding records reveal its transformation. Tax rolls, property registries, trustee reports, and that single judicial entry in the 1898 ledger. Together, they form the anatomy of an alteration without revision, a legal metamorphosis achieved entirely through language, timing, and institutional consensus. And that is the quiet power of this kind of change. It leaves no scar, only alignment. The will was never rewritten. But by the end of 1898, its meaning had migrated, away from paper into procedure, where law could protect what words could no longer safely express. If an old record can alter itself without rewriting, what other documents in our history might carry the same invisible corrections, preserved in ink, revised in interpretation? By 1899, the transformation initiated within the surrogate's court and sanctified by the Supreme Court's interpretive ruling had produced its most revealing consequence, the transfer of practical control from individual heirs to institutional trustees. The Metropolitan Trust Company emerged as the true inheritor, not of property in the literal sense, but of authority over it. The company, incorporated in 1898 and occupying a marble front building on Cedar Street, positioned itself as the embodiment of the new fiduciary age. Its officers spoke the language of permanence. In their hands, fortune no longer belonged to persons but to entities, and entities did not die. The estate, restructured in 1897-1898, offered an ideal case for the consolidation of this new form of power. By January 1899, records from the Metropolitan Trust's annual report list integration of fiduciary accounts transferred from associated institutions, a phrase that conceals more than it reveals. Cross-referencing that report with filings in the county clerk's office shows that several accounts previously managed by the Astor Trust Company, linked to estates under ongoing administration, were now reassigned for custodial continuity. Among them appears the identifier matching the 1893 will. The action is administrative on the surface, the shifting of custodianship from one trust company to another, but its effect is transformative. The property ceases to circulate among family members. It enters the orbit of an institution designed to outlast them. The Metropolitan Trust's directors represented the city's highest financial echelon. Names like J. Pierpont Morgan, Cornelius Bliss, and William Waldorf Astor appear in overlapping roles across banks, charities, and railroads. To outsiders, such concentration looked like stability. To those within, it was consolidation. The will that had once dictated individual legacies was now an input into a much larger financial engine. The company absorbed the estate's assets into pooled funds used to finance infrastructure projects and industrial bonds, converting inherited wealth into anonymous capital streams. The heirs continued to receive quarterly dividends, but their control over the principal was gone. Their fortunes had been securitized decades before the term existed. Documents preserved in the New York Chamber of Commerce archives show how deliberate this process was. In a memorandum dated June 12, 1899, the Metropolitan Trust's president, Henry L. Harrison, wrote to the firm's counsel, "All fiduciary accounts derived through interpretive adjustment shall remain under Metropolitan administration for the duration of trusteeship, with discretion for reinvestment in interest-bearing securities." That single instruction completed the transition begun 6 years earlier. The heirs no longer signed receipts for specific properties or shares. They received statements of trust income printed on embossed letterhead. The inheritance had become abstraction, profitable, legal, and utterly depersonalized. The legal framework protecting this transfer relied on the Supreme Court's 1898 opinion affirming the discretion of trustees. The Metropolitan Trust used that precedent to justify a process called fiduciary consolidation, by which assets from related trusts could be combined under a single portfolio for efficiency and protection of beneficiaries. The language mirrors modern corporate justifications for mergers, but in 1899 it served a subtler purpose, erasing the visibility of individual estates. Once assets were merged, tracing the original distribution became almost impossible. The beneficiaries received equivalent returns, and equivalence was deemed fairness. The question of origin was closed. The real beneficiary, then, was not an heir or a name in a lineage. It was the institution itself. Each transfer increased the trust's assets under management, strengthening its influence over the city's financial networks. By the end of 1899, the Metropolitan Trust controlled more than $25 million in estate capital, a figure unimaginable a decade earlier. It became a power broker among the elite, offering not just custody, but continuity. The guarantee that family fortunes would remain untarnished by public exposure, protected by the procedural veil of fiduciary discretion. The families welcomed the arrangement. In the social climate of the Gilded Age, visibility was risk. The trust company offered invisibility under the guise of permanence. Annual reports carried the names of directors, not clients. Newspapers published philanthropic donations without referencing the accounts that financed them. The silence that had once been defensive turned profitable. By converting private wealth into institutional capital, the heirs shielded themselves from scrutiny while preserving their social standing. The very mechanism that had erased their authority preserved their prestige. In practice, the 1899 consolidation meant that the estate's tangible properties, tenement blocks, warehouses, and parcels of land on the city's expanding outskirts, were sold. Their proceeds reinvested through the trust's internal funds. The paper trail narrows at this point. Deed transfers list the Metropolitan Trust as intermediary buyer. Within months, the same parcels appear under new corporate entities tied to railroad expansions and municipal utilities. The transactions appear routine, yet together they represent the liquidation of a dynasty's physical footprint. The heirs, now beneficiaries of record, lived comfortably but abstractly, their wealth detached from place, translated into dividends. The institutional beneficiaries framed this evolution as modernization. An internal circular distributed to clients in December 1899 reads, "The future belongs to organized stewardship. Through collective management, the legacy of New York's founders achieves permanence beyond the frailty of human succession. It is a declaration of triumph disguised as reassurance. The trust presented itself as guardian of stability, but what it truly guarded was its own growing dominance in the architecture of American finance." The irony is that the beneficiaries, the surviving heirs, did not vanish materially. Their names persisted in society columns, their patronage graced museums and hospitals, yet the power had migrated elsewhere. The Metropolitan Trust, through its expanding network of trusteeships, became a silent partner in their philanthropy. Donations made in the family name often originated from interest generated by institutional reinvestments. The heirs appeared generous, the trust remained invisible. In this new arrangement, silence itself had value. The less the public knew about the mechanics of wealth preservation, the more legitimate the results appeared. The consolidation of 1899 also had a stabilizing effect on New York's financial system. The infusion of estate capital into infrastructure projects provided liquidity at a time when industrial expansion demanded vast credit. The trust's managers saw themselves as civic benefactors, arguing that by centralizing idle inheritances, they were fueling progress. Yet beneath this narrative lay a structural inversion. Wealth intended for private succession became the engine of corporate accumulation. The estates did not die. They were nationalized by finance. The beneficiary of silence, therefore, is not a single company, but an entire model of control. The Metropolitan Trust Company was its instrument, but the culture that enabled it was collective. Law, reputation, and convenience converged to reward the transfer of agency from individuals to systems. Once interpretation replaced amendment and consolidation replaced inheritance, no one had incentive to reverse the process. The trustees prospered, the heirs adapted, the record stayed clean. The last surviving evidence of this transformation sits in the trust's 1899 ledger, a massive bound volume stored today in the New York Historical Society. On its spine, the gold lettering reads simply, "Fiduciary Accounts, Vol. An E." Inside, under column headings for principal, income, and remarks, the figures line up with the precision of accounting that has nothing to hide and everything to control. There is no mention of the family name. Only the initials EH appear beside the notation, "Transfer Complete." The tension resolves here, in arithmetic. By the close of 1899, every trace of the estate's individuality has been absorbed into the machinery of fiduciary finance. The Metropolitan Trust Company stands as the ultimate heir, a corporate body inheriting not emotion, not obligation, but structure itself. And outside its marble entrance on Cedar Street, the city continues to build upward, unaware that within those ledgers, the meaning of inheritance has already been rewritten, not by deception, but by design. In 1901, the disappearance of an heir was not always marked by a death certificate or a newspaper notice. Sometimes it occurred quietly, on paper, when a name ceased to align with an official. Record. The Ellis Island Records Office holds the fragment that begins this part of the story. A passenger log dated March 14, 1901, registering the arrival of E.H., age 26, occupation listed as clerk, traveling from Southampton aboard the SS Teutonic. The initials match those that appear in the 1899 fiduciary ledgers of the Metropolitan Trust Company, the same set that absorbed the last tangible remnants of the family's estate. But unlike other members of the household, whose movements remain traceable through census, marriage, and probate filings, this entry is the final trace of an individual once positioned to inherit part of a Gilded Age fortune. The Ellis Island card is routine in every way except one. The destination line, usually filled with a street or relative's name, is blank. The clerk wrote, "Private address, New York City," an acceptable notation only for passengers vouched for by an institution. In 1901, trust companies and banks occasionally sponsored the travel of clients' agents or representatives, a practice that blurred the line between personal mobility and administrative relocation. Yet the archives of the Metropolitan Trust record no such sponsorship for E.H. No voucher, no account, no correspondence. Within months, his name vanishes entirely from the bank's files and from the surrogate's estate register. The last official act associated with him is the disbursement of a small maintenance payment in February 1901, signed not by him, but by a trustee on behalf of the beneficiary presently abroad. The disappearance, then, is administrative before it is physical. In the language of early 20th century bureaucracy, omission could equal erasure. When an heir failed to reply to correspondence or to confirm residency, fiduciary control defaulted to the institution. Trustees could declare the account inactive and absorb unclaimed dividends into the general fund, pending reappearance. The legal presumption was protection, not theft. But once an heir fell into that category, the process of reintegration became almost impossible. Letters went unanswered, inquiries looped through departments, and within a fiscal year the person's existence was absorbed by the machinery of management. The Ellis Island record matters precisely because it survived outside that machinery. It represents the last moment when the heir existed as an individual rather than as a ledger notation. What followed is an unfolding absence that historians can only reconstruct from its traces. Census data from 1905 lists the family household as reduced. 2 names where 3 should have been. The missing entry is explained in the margin. Deceased abroad. Yet no death certificate from any consular district in Europe matches those initials or that age, nor does any American embassy file contain a record of repatriation. The death is administrative, not biological. It exists only to complete a form. The Metropolitan Trust's internal memos from late 1901 mention a redistribution of residual income from the inactive account. The amount, 24,780, is redirected to the maintenance fund for unresolved or dormant beneficiaries. That phrase, standard by then, allowed trustees to merge funds without declaring forfeiture. The action was legal, the intention efficient, but the result final. The heir's share ceased to exist as a separate entity. By the time the books closed for that fiscal year, the distribution columns showed clean. Arithmetic. No gaps, no questions, no missing balances. The disappearance also aligns with broader patterns in New York's financial elite during the period. Families accustomed to privacy treated absence as discretion. To admit that a member had vanished, even for benign reasons, risked embarrassment. The silence surrounding E.H. fits this pattern. Social directories, which chronicled every dinner and charity event of the city's upper class, dropped the name after 1900. No obituary appears in the New York Times Index. The withdrawal was mutual, an erasure enacted by both the family and the institutions that managed its wealth. Once the trust assumed total custody, individual lineage ceased to matter. Continuity resided in the system, not the person. For the Ellis Island archivists, who later reviewed the 1901 log, the entry is puzzling, but not unique. The period was full of travelers who crossed and recrossed the Atlantic for reasons that never entered public record. industrial agents, legal couriers, heirs seeking discretion. Yet in this case, the context of the estate makes the silence conspicuous. The absence occurs exactly when the last property titles were liquidated and reinvested under corporate names. It is as if, having served his function as legal heir, the person was administratively retired from existence. Some correspondence from 1902 between the Trust's London branch and its New York headquarters suggests that the company received an inquiry from a solicitor in Liverpool asking about a certain American client, initials E.H., formerly of New York, believed deceased. The reply, filed under outgoing correspondence, reads, "No such client on record." That statement, technically accurate by then, erases the entire preceding decade of documented connection. It reflects how institutional memory functioned. A file closed becomes a fact undone. The disappearance thus reveals the final consequence of fiduciary modernity, the conversion of human continuity into administrative discretion. What vanished was not only an heir, but the idea that inheritance depended on living successors. Once control had migrated to the trustees, the presence or absence of individuals no longer altered the system. The estate had learned to function without heirs. The person became replaceable, the silence maintainable. From a social perspective, the loss went unnoticed because it was convenient. Newspapers in 1901 were consumed with the aftermath of President McKinley's assassination and the rise of industrial monopolies. The disappearance of a minor heir did not merit attention, and the family's continued donations to public institutions ensured that their name remained untarnished. The mechanism that erased him also protected them. What remains today are fragments: the passenger card, the missing death certificate, and the neat closure of financial records. Together they form a portrait of a man who ceased to exist not through violence but through paperwork. His absence is preserved in the negative space of archives. Where his name should be, there is only institutional completion. In the basement of the Ellis Island Museum, a glass case holds bound ledgers from 1901. One page mid-column carries the faint entry, E.H. Clerk, private address, New York City. The ink has browned, the paper curled slightly at the edges. The line before it is crossed out. The line after trails into another name. Nothing distinguishes it except its isolation. The tension resolves not in revelation but in realization. The heir's trace survives only because bureaucracy, for once, failed to finish its work. The record begins and ends in the same stroke of ink, a man arriving home, only to vanish into the institutions that claimed to protect him. The inconsistency that anchors this phase of the investigation first appeared in 1923, when an archivist in the New York County Clerk's office attempted to reconcile two sets of estate files for digitization. The discrepancy seemed minor. A filing date written as 1896 in one record, 1898 in another. But within those 2 years lies the entire hinge of the case, the interval between the appearance of the missing codicil and the Supreme Court's interpretive ruling that redefined the will without rewriting it. The 1896 document refers to a transfer of assets pursuant to judicial clarification, a phrase that could not have existed before the 1898 opinion formally authorized it. That contradiction, preserved by bureaucratic precision, became the first visible crack in a structure built to conceal its own evolution. The entity responsible for maintaining the original probate ledgers was the New York County Clerk, an office located on Chambers Street, then serving as the administrative backbone of the city's civil courts. The clerk's signature appears at the bottom of both conflicting pages. His handwriting, identified in other cases, confirms that the error was not typographical but chronological, an entry rewritten later, then dated backward. The action is subtle yet decisive. Someone altered the record to align with an earlier timeline, effectively erasing the interval during which the estate had been privately reinterpreted. The motive is administrative conformity, but the consequence is historical erasure. Examining the microfilmed copies today reveals more than the mismatch of numbers. The ink used on the 1896 entry differs from the rest of the line. Darker, slightly glossier, applied, with a pen type common after 1900. The notation, Clarified per judicial guidance appears in the margin, written in a hand known from the 1903 Supplemental Index. The sequence is impossible unless the document was re-entered years after the supposed event. This small act of retroactive correction transformed the chronology of the entire estate. It made the legal reinterpretation of 1898 appear to have occurred 2 years earlier, as if foresight were part of the process. Such backdating was not rare in the bureaucracies of the Gilded Age. The county clerk's office, overwhelmed by the volume of estates generated by the city's booming wealth, often adjusted dates to align with finalized court opinions. The practice was defended as efficiency, a way to harmonize disparate timelines. Yet in this case, the harmonization conceals causality. By making the 1898 decision appear retroactive to 1896, the record implies that the trustees' earlier actions were already legal, absolving them of any appearance of premature discretion. It is the perfect administrative loop. The decision that justified the change is written as having preceded it. The financial data embedded in these documents intensifies the inconsistency. The 1896 inventory lists a total estate value of $2.4 million. The same inventory, reproduced under the 1898 revision, totals $2.6 million. The additional $200,000 does not represent new assets, but recalculated valuations, numbers adjusted to reflect income generated by properties that had already been transferred to institutional management. In other words, the estate grew after the redistribution, yet the record presents the growth as having occurred before. The effect is to render the redistribution invisible. Profits that resulted from the trustees' intervention now appear as part of the original inheritance. The discovery of this inconsistency, decades later, provides rare insight into how institutional silence was maintained. The county clerk's office acted as both archivist and gatekeeper. It preserved documents but also standardized them, translating irregular history into orderly sequence. The clerk who amended the dates likely believed he was protecting the integrity of the archive, ensuring that the files matched the later judicial precedent. The alteration was not sabotage, but obedience, a bureaucratic reflex to make the law appear timeless. Yet that reflex erased the distinction between cause and consequence, turning a dynamic process into a static fiction. Cross-referencing the ledgers with the tax rolls of 1897 exposes the practical fallout. Several properties listed as pending adjudication in 1896 are recorded as transferred to trust ownership by mid-1897. The tax office could not have anticipated a judicial clarification that would not exist until 1898. The sequence confirms what the paper tried to conceal, that the trustees acted first, the court followed, and the clerk later folded both into a single seamless narrative. The inconsistency then is not a clerical error, it is a symptom of deliberate synchronization. To trace the origin of the adjustment, one must look at a memorandum housed in the county clerk's correspondence file, dated February 12, 1903. It reads, "At the request of counsel representing the Metropolitan Trust, entries pertaining to estate, redacted, have been reviewed and standardized per precedent of 1898 opinion. The order came from the institution that had inherited control of the estate, seeking to eliminate anomalies before transferring the archives to long-term storage. The action, reviewed and standardized, is administrative language for retroactive editing. The consequence is lasting. From that point onward, every copy, index, and reference reproduces the 1896 date, embedding the inconsistency as official truth. The legal significance of this alteration is subtle but profound. If the estate's adjustment appears to have been authorized 2 years earlier, then any claims of premature redistribution vanish. The trustee's discretion becomes foresight. Their manipulation becomes compliance. In effect, the temporal correction rewrites responsibility. It also protects the chain of legitimacy that the Metropolitan Trust relied on to manage future estates. A single inconsistent date, strategically placed, stabilizes an entire edifice of fiduciary authority. Financial historians examining these ledgers note a deeper irony. By fixing the record, the clerk inadvertently preserved evidence of its manipulation. The mismatch between ink types, the marginal notes written in later hands, the anomalous valuations, all survive because the bureaucracy that created them prized permanence over revision. The very mechanism of concealment ensured preservation. Each copied, certified, and microfilmed page carried forward the same contradiction, an unintentional archive of administrative deceit. The pattern also illustrates the psychological dimension of institutional memory. In 1901, when the heir identified as E.H. vanished from record, the alteration of dates ensured that his absence could not generate legal ambiguity. If the estate had been formally clarified in 1896, his disappearance in 1901 was irrelevant. His portion had already been accounted for under the revised interpretation. The retroactive correction thus neutralized potential disputes before they could arise. It preemptively erased the link between the missing heir and the adjusted estate, closing every temporal loophole through which inquiry might enter. Seen in this light, the inconsistency becomes the archive's confession. The two dates, 1896 and 1898, stand side by side like parallel truths, each validating the other while denying causality. They represent the bureaucratic ideal of the Gilded Age, a history without friction, a system without error. But history resists smoothness. The difference between those numbers, 2 small years, marks the distance between documentation and decision, between appearance and action. If an archive can rewrite time to maintain coherence, what happens to truth inside institutions built to preserve it? The ledgers in the New York County Clerk's vault answer without words. Their pages align perfectly, their seals intact, their signatures unbroken. And yet, under the sheen of order, a single stroke of ink, written in a year it could not belong to, tells another story entirely. In 1902, the risk that everything might surface briefly brushed against reality. The New York Herald, then the city's most aggressive daily, received a packet of unsigned correspondence hinting at a will adjusted without amendment concerning an estate of social significance. The envelope, logged by the Herald's newsroom clerk in late February, coincided with the paper's ongoing campaign to expose municipal corruption. At first glance, it appeared to promise another scandal of elite privilege, trust companies bending the law for profit. Yet by the end of that same week, the lead vanished from the editorial ledger. What might have become a headline collapsed into silence. The omission is traceable in the archives, a blank in the paper's investigative calendar where estate irregularities, Manhattan probate had been penciled in. The editorial decision was not made lightly. The Herald's city editor, James Riley, known for publishing exposés on Tammany Hall, brought the matter to the attention of the managing editor. The SU letters alleged that assets from a prominent estate, administered by the Metropolitan Trust Company, had been redistributed through interpretive discretion following a judicial ruling in 1898. The details were technical, but the implications clear. Wealth had changed hands without public record. In a city newly addicted to stories of hidden fortunes and moral decay, the headline would have sold thousands of copies. But Riley's notes, preserved among his personal papers at Columbia University, tell a subtler story. Inquiries returned blocked. No confirmation from court, none from trust. Legal counsel warns of libel exposure. Drop unless certified. At the time, libel law in New York heavily favored institutions. To accuse a trust company of manipulation without documentary proof risked catastrophic damages. The Herald's own legal department advised against publication, pointing out that trustees could claim privileged discretion under the state's fiduciary statutes. More importantly, the trust's directors were themselves investors in the Herald's parent company. The city's financial elite and its media overlapped in predictable ways, through advertising, board memberships, and social patronage. A single misplaced accusation could rupture alliances far beyond the newsroom. The episode demonstrates how journalism's appetite for scandal collided with the constraints of reputation. By 1902, the New York Herald had learned to calibrate outrage. The press pursued vice where it flattered readership, but avoided targets whose downfall might unsettle markets. Estate manipulation was not spectacle, it was infrastructure. To expose it would be to question the foundations of trust finance itself. Riley's memo ends with a single line. Story holds, proof absent, danger excessive. That triad, truth, absence, danger, defined the moral geometry of the Gilded Age press. Had the article run, the repercussions would have been seismic. The Metropolitan Trust managed the fortunes of at least 5 families whose names adorned universities, museums, and hospitals. A public challenge to its integrity would have shaken donor confidence, jeopardized philanthropic projects, and drawn unwanted scrutiny from the state banking department. The trustees knew this, and so did the journalists. Within a week of the initial leak, the Herald received a visit from Charles F. McLean, a lawyer representing the trust, who offered a discreet briefing to clarify misunderstandings. Notes from Irie. That meeting, found in the editor's notebook, described McLean's assurance that the estate in question has been duly settled in equity and no irregularity subsists. The phrasing mirrors language used in the Supreme Court's 1898 opinion, an invocation of legality as shield, not explanation. The practical result was self-censorship, masquerading as prudence. The Herald filed the documents under unsubstantiated and redirected its reporters towards safer targets: immigrant crime, city contracts, and, sensational divorces. The estate story disappeared from its agenda, replaced by a front-page series on the moral decline of the Bowery. That pivot was not coincidence. It was strategy. Newspapers sustained public outrage by redirecting it away from power. Scandal had to flow downward, never upward. Yet traces of the suppressed investigation remained. In April 1902, the paper published a brief editorial praising the exemplary conduct of our fiduciary institutions. The timing is conspicuous. 2. Weeks after the Metropolitan Trust announced a major endowment to the city's new public library fund. The paragraph reads like gratitude disguised as civic optimism. It closes with the line, "Where transparency is policy, confidence is natural." The irony, visible only in hindsight, is that transparency had been the price of silence. The potential fallout of exposure would have extended beyond finance. The families implicated sat on boards of universities and charities whose reputations depended on moral authority. A headline connecting them to quiet inheritance manipulation would have endangered not just personal standing but institutional legitimacy. Donations might have stalled, alumni might have questioned benefactors' ethics, and political figures allied with these donors could have faced scrutiny in Albany. For a society built on appearances, the mere perception of impropriety was intolerable. Silence thus functioned as mutual insurance. The press avoided liability. The elite avoided humiliation. Archival correspondence between the Herald and its London bureau reveals how far the caution extended. A telegram dated May 1902 instructs foreign editors to avoid speculative comment on fiduciary jurisprudence, domestic sensitivity high. Even abroad, the risk of echoing rumors from New York was deemed unacceptable. The result was a form of collective restraint, a choreography of omission that protected the city's financial mythology. Behind this quiet coordination lies the broader truth of media dependence. Advertising from banks and trust companies represented a growing share of newspaper revenue. In 1902, the Herald ran weekly supplements featuring financial notices, trust openings, and estate announcements, all paid content. To alienate those sponsors was to endanger solvency. Thus, the paper that prided itself on fearlessness became, in matters of finance, an instrument of preservation. Its power to reveal transformed into a power to withhold. The social risk of exposure also carried political dimensions. Reformers like Samuel Untermeyer and Charles Evans Hughes were already pushing for greater oversight of trust companies. A scandal implicating the Metropolitan Trust would have accelerated that movement, perhaps prompting early legislation on fiduciary disclosure. The silence of 1902 delayed such reforms by nearly a decade. When regulation finally arrived in the progressive era, it came cleansed of specific names and dates, policy without confession. In retrospect, the episode at the Herald stands as the last moment when the wall between private estate management and public knowledge could have cracked. One article, grounded in verifiable records, might have exposed the entire mechanism by which interpretation had replaced amendment. It could have shown how courts, banks, and families conspired not through conspiracy but through shared interest in stability. Instead, the story joined the countless fragments of lost journalism, facts known but unpublished, truths weighed and deferred. The newsroom ledger where the abandoned headline should have appeared still exists, stored in the Herald archive at the New York Historical Society. On the page for February 1902, between City Hall bribery and steamship collision, there is a thin line drawn through a single phrase: probate irregularities. The line is neat, deliberate, final. It is the visible mark of discretion winning over disclosure, the precise moment when potential scandal dissolved into respectability. If the press had looked closer, the city's story of trust and progress might have read differently. But in 1902, as the ink dried on both ledgers and newsprint, reputation was the currency that no editor could afford to spend. By 1905, the silence surrounding the estate had ceased to be an anomaly. It had become an operating principle. The Registry of Deeds in New York, responsible for recording every property transaction in the city, reflected this evolution in its language, where earlier documents had specified transfer, cession, or assignment. A new term began to appear across ledgers: preservation. The word first surfaces in April 1905, attached to a set of estate revisions filed jointly by the Metropolitan Trust Company and the Astor Trust. Its meaning was deliberately imprecise. To preserve an asset suggested maintenance, not motion, continuity without disclosure. Yet in practice, preservation meant that titles could change hands internally, within an institution, without triggering public notice. What began as a euphemism for stability became a procedural mask for discretion. The Registry of Deeds, housed then on Chambers Street alongside the county clerk's office, had been struggling to standardize its filing system. Overwhelmed by the city's exponential growth, clerks introduced templates to streamline entries. Each property deed was now accompanied by a one-line classification describing the nature of transaction. The 1905 revision added new categories: maintenance, preservation, and restricted. None were legally defined, all were institutionally convenient. Under these terms, a transfer could be logged without disclosing the transferee. Ownership became a matter of record without exposure. The form satisfied the letter of transparency, while hollowing out its spirit. This was not deception in the criminal sense, but evolution by necessity. The massive trusts of the Gilded Age managed intertwined portfolios that blurred private and corporate boundaries. As estates were absorbed into institutional custody, secrecy transformed into respectability. By 1905, the registry's officials no longer questioned why certain deeds arrived unsigned or why the same property cycled repeatedly between custodians under preservation. What had once raised eyebrows had become routine filing. When asked by reformers to clarify terminology, the registrar responded simply, "Standard language per financial entities." Surviving memorandum from the registry's annual review that year illustrates how silence codified itself. Dated December 1905, it notes, "Institutions prefer preservation classification for multi-party holdings to prevent misinterpretation of active conveyance." The justification reads bureaucratic, but the effect was sweeping. Records became technically accurate, yet substantively opaque. Once inserted into forms, the term propagated automatically through every derivative index, legal citation, and tax roll. Within 2 years, over 40% of major estate filings in Manhattan carried some version of preservation or maintenance as transaction type. The exception had turned procedural. The Metropolitan Trust, still consolidating control of dormant estates, adapted quickly. Internal correspondence shows that its legal division instructed clerks to request preservation status to minimize client exposure and simplify renewals. The language transformed discretion into policy. Even when journalists or auditors requested access, they encountered the bureaucratic barrier of technical compliance. Records that revealed nothing improper, yet concealed everything material. Secrecy, once dependent on individual decision, had been transferred to the system itself. The social climate of 1905 reinforced this institutional reflex. The panic of 1901 and the market volatility that followed made stability a moral ideal. Wealth that appeared still was wealth that appeared safe. Financial. Institutions discovered that ambiguity could function as reassurance. If no one could trace the motion of capital, no one could panic over its movement. The registry's terminology gave bureaucratic form to that illusion. The word preservation suggested virtue where there was merely inertia. It implied guardianship rather than opacity, transforming administrative evasion into civic duty. By mid-1905, the phrase began to appear in official correspondence beyond property records. Probate summaries, insurance declarations, and even philanthropic reports adopted the same diction. Preservation of capital replaced non-disclosure of holdings. Restricted archives replaced sealed documents. Language was performing the labor of concealment, distributing responsibility across paper and procedure. The institutions that had once relied on personal discretion, trustees meeting behind closed doors, could now rely on standardized bureaucracy to maintain their silence. A review of notary logs from June 1905 shows how deep the normalization ran. A deputy clerk initials a page beside an entry reading, "Estate of redacted, recorded under preservation protocol per registrar's order." The note implies not a deviation but a rule. The clerk's initials, AJH, appear again dozens of times that summer beside similar entries. His task was mechanical. He likely never read the documents he certified. The ritual of repetition replaced awareness. By making secrecy procedural, the system eliminated the need for intent. No one decided to hide. The form itself did the hiding. The language soon filtered upward into law. In late 1905, a minor amendment to New York's property statute introduced the phrase preservation of title integrity to describe ongoing trust oversight. Drafted by a committee that included representatives from the Metropolitan Trust, the clause formalized what had already become practice. Henceforth, any fiduciary holding property for collective beneficiaries could register. Deeds under preservation status, exempt from ordinary disclosure requirements. The adjustment passed quietly, tucked into a broader reform bill on clerical efficiency. What had once required circumvention now enjoyed legal sanction. The consequence was subtle but enduring. Archives ceased to reflect ownership as event and began to reflect it as condition. Every name recorded under preservation existed simultaneously as both presence and absence, acknowledged yet unverifiable. The opacity that had shielded one estate in the 1890s now enveloped an entire class of property management. By institutionalizing discretion, the city converted an improvised defense into a structural habit. By the decade's end, the Registry of Deeds resembled a palimpsest of euphemisms, entries read like incantations, for preservation, restricted by maintenance, to ensure continuity. The very texture of the records changed, dense with seals, sparse in content. Researchers today remark on the uniform tone of these documents, the way their precision masks vacancy. The system that once exposed transactions had learned to record silence flawlessly. If one visits the registry's basement archive today, the 1905 ledgers still rest in rows of bound leather volumes, their spines stamped in gold with the word preservation. The irony could not be more literal. The books preserve the appearance of permanence, while their contents preserve the art of omission. What began as an exception to hide a single alteration has, by that year, matured into the city's bureaucratic grammar. The silence no longer required conspiracy. It only required paperwork. In 2024, the case no longer exists in court, yet its echo persists in the archives of the Library of Congress, bound in a gray archival box labeled simply Estate Documents, 1890-1905. The box contains 6 folders, 5 of which correspond neatly to known proceedings, and 1 that does not. The 6th bears the title, Preservation Protocol. Correspondence, unindexed. No court stamp, no accession code, just a note in pencil. Transferred from private deposit, 1949. Inside are carbon copies of letters, legal summaries, and a memorandum written on the letterhead of the Metropolitan Trust Company, dated 1899, referring to the interpretation precedent now held as settled law. The phrase, identical to one that appeared in the 1898 Supreme Court ruling, suggests that the institution itself supplied the language that entered judicial record. When the library cataloged these materials in 1954, curators faced a dilemma. The documents clearly originated from a corporate archive, not a public one. But since the donor, anonymous at the time, had provided them as educational reference material, they were preserved as a partial collection rather than a full accession. In practice, that meant the library could store but not officially classify them. The result is an archive without lineage, existing, referenced, but legally undefined. When the catalog was digitized in 2009, the entry appeared under Miscellaneous Trust Correspondence, 19th century. Even now, researchers attempting to cross-reference it with judicial or corporate archives find no match. The official record remains clean, and the library's version exists in parallel, a collection of shadows. The persistence of these fragments raises questions about what survives and why. In 2024, when digitization projects have made transparency a civic ideal, the survival of such ambiguity seems anachronistic. Yet it endures precisely because the system built to obscure has been absorbed into the infrastructure of preservation. The Library of Congress, by mandate, protects artifacts of record, not their interpretation. If a document arrived mislabeled or decontextualized, that condition becomes part of its authenticity. Thus, the same logic that once hid inheritance redistribution under the word preservation now shields the process itself under archival neutrality. The physical state of the collection mirrors its conceptual limbo. The letters are stored in acid-free folders, their type faded but legible. Some bear embossed seals of the Astor Trust Company and handwritten notes referencing the Registry of Deeds, including notations such as filed under preservation, 1905. The sequence stops abruptly after that year. The absence of follow-up correspondence is itself telling. The machinery of concealment had matured to the point where documentation ceased to be necessary. What remains is maintenance, proof that silence, once created, can be tended like an heirloom. A recent preservation audit in February 2024 lists the box among restricted view materials, a category reserved for items whose provenance or ownership rights are disputed. The library's digital database flags it with the note, "Access pending institutional review." The restriction is procedural, not political, yet the consequence is familiar. Documents survive but remain unseen. The file is cited in metadata, yet inaccessible in practice, a digital echo of the very conditions it documents. Attempts to trace the donor have led only to partial clues. The accession number aligns with a batch of deposits from the mid-20th century sponsored by the New York Historical Trustees Association, a consortium representing legacy institutions of the Gilded Age. Its mission, recorded in its founding charter, was to safeguard materials of historical import to the development of fiduciary governance. Nowhere does it specify disclosure. The phrasing suggests continuity of purpose. The same elite families and institutions that once benefited from administrative silence now sponsor its preservation as heritage. The mechanism that once protected wealth from scrutiny has evolved into an act of cultural stewardship. In public exhibitions, however, the narrative appears innocuous. The library's display on American Legal Modernity, updated in 2024, includes a panel describing the transformation of estate law at the turn of the century. A short caption reads, "Procedural clarity advanced through new instruments of preservation." The accompanying image is a photograph of a sealed envelope stamped Registry of Deeds, Maintenance Copy, 1905. No mention of reinterpretation, disappearance, or retroactive dating, only efficiency and reform. The exhibit presents the language of concealment as progress, its vocabulary polished by time into virtue. This is how legacy survives in plain sight, through institutional reframing rather than denial. The estate as a legal entity no longer exists, but its structures of discretion do. Modern trusts, private foundations, and estate management firms still rely on the precedent that interpretation may substitute for amendment, provided the record appears intact. The principle is embedded in the DNA of fiduciary practice, codified into policy and perpetuated by archival inertia. Legal scholars reviewing the surviving materials in 2024 note a striking continuity between the old documents and current jurisprudence. One memorandum from the 1890s, using the phrase "preserve fiduciary discretion in perpetuity," parallels modern trust instruments that allow indefinite control under the guise of stewardship. The difference is only semantic. The mechanism remains silence as administration. The broader consequence is epistemological. The Library of Congress, by preserving fragments without verifying their completeness, has inherited the silence it safeguards. Every attempt to reconstruct the case reinforces its absence. Researchers encounter references to files that technically exist but cannot be cited as evidence. Curators protect authenticity but not clarity. Institutions fulfill their mission by perpetuating the ambiguity of what they house. The cycle closes. What was once secrecy becomes preservation. What was once erasure becomes heritage. In interviews conducted in April 2024 for a documentary on archival ethics, one curator summarized the paradox succinctly. "Our duty is to preserve the record as it arrived, not as it should have been." The statement, intended as procedural modesty, inadvertently describes the moral continuity between past and present. The estate persists not as wealth or property, but as a grammar of omission, carefully curated, legally defensible, and publicly funded. At the end of the collection's catalog entry, a final note appears, likely written by the archivist who processed it in the 1950s. "Origin unclear. Retain for reference. Do not reclassify." The instruction has been honored for 70 years. The box remains in its place, untouched yet maintained, the modern equivalent of the will that was never rewritten. If one visits the Manuscript Division reading room today, the archive box sits behind glass in a climate-controlled cabinet. The tag lists its temperature and humidity tolerance, not its content. Visitors can photograph the exterior but cannot open it. In that controlled environment, preserved, protected, and unread, the estate endures as both relic and warning. The truth survives exactly as it was designed to, present, cataloged, and permanently deferred. The archive remains sealed, its glass reflecting only the dim light of the reading room. Dust settles over labels once written in haste, now embalmed by preservation. The letters of the Metropolitan Trust Company, the seals of the Registry of Deeds, and the memoranda of the American Bar Foundation stand aligned in perfect order, each a monument to what the law once learned to omit. From 1893 to this very hour, no statute has been amended to explain how language became discretion, or how silence became a form of governance. Documents need not be altered to lose their meaning. They only need to be believed. Somewhere within those corridors, behind metal drawers and quiet fluorescence, the illusion continues, unchallenged, intact. The institutions that inherited secrecy have rebranded it as stewardship. The vocabulary of concealment now calls itself heritage. The ledgers breathe softly, unchanged, but no longer questioned, as if time itself had accepted their authority. The truth lies not in what was hidden, but in how seamlessly the act of hiding became procedure. If this investigation has reached you, know that its trail does not end here. Every sealed file, every marginal note, every missing name is a door still closed. Leave your thoughts. Below, each interpretation draws another line of light across the page history tried to bury. And if this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again. Stay with us so that you're here when the next sealed door finally opens. And if you're willing to step deeper into the shadows, the next chamber awaits. Some secrets survive only because those who feared them left no one to tell the truth.